Judgment in the matter of MacDonald and another versus Carnbroe Estates Limited, Scotland.
Lord Hodge will explain the decision of the court.
When a company falls into insolvency, the law seeks to protect its unpaid creditors. It does so by reversing recent transactions by which its directors have disposed of its assets either for no consideration or at an undervalue. These transactions, known as gratuitous alienations, can be challenged, usually by the liquidator of the insolvent company, under Section 242 of the Insolvency Act 1986. In this appeal, a Scottish company, Grampian McLennan's Distribution Services Limited, which I will call Grampian, was in financial difficulty and was bought by a businessman who sought to save it. Unfortunately, soon after he acquired shares in Grampian, it suffered a cash flow crisis and couldn't be saved. So the businessman sold off the company's vehicles and in July 2014 sold its principal asset, which was its distribution centre and headquarters, which I will call the property, to another businessman whom he had known for years, who acquired the property through his company, Carnbroe Estates Limited. The property had been valued in July 2013 at £1.2 million on the open market and at £800,000 if sold on a restricted marketing period of 180 days. Notwithstanding that, Carnbroe acquired the property for £550,000, of which it paid only about £473,000. That was the sum which enabled Grampian to repay its debt to its bank. Carnbroe didn't pay the balance of the purchase price until long after the liquidators of Grampian had raised an action to annul the transaction. While the bank was paid off, Grampian's debt to the revenue of about £500,000 remained unpaid, and HM Revenue and Customs Commissioners successfully applied for Grampian to be wound up. The liquidators challenged the sale of the property as a gratuitous alienation. Expert evidence at the proof valued the property on the open market at the time of sale in the range of £740,000 to £820,000, well above the price of the actual sale. At first instance, the Lord Ordinary held that it was not a gratuitous alienation, as, in his judgment, Carnbroe had paid adequate consideration in a context in which Grampian needed a quick sale to survive. Such a quick sale inevitably involved a significantly reduced price. The liquidators appealed to the inner house of the Court of Session, who unanimously allowed their appeal, holding that there was no urgency to dispose the property as, by the time of the sale, Grampian was no longer trading, but was in substance conducting an informal winding up of its business. In selling the property, it wasn't seeking to maintain its cash flow in order to stay in business. It had ceased business. Carnbroe appealed to this court and argued that the inner house had erred in its interpretation of the concept of adequate consideration. I will call that the first question. During the hearing, this court raised with the parties a separate question, namely, what were the remedies which the court could give under Section 242, subsection 4 of the 1986 Act, and counsel produced very helpful written submissions on this issue after the hearing. That is the second question. In a unanimous judgment, this court allows the appeal, but only to the extent of remitting to the inner house a matter arising out of the second question. That is to say, that this court invites the inner house to consider what is the appropriate remedy under Section 2424 of the 1986 Act. In relation to the first question, the court agrees with the inner house that the sale of the property was a gratuitous alienation because it was not sold for an adequate consideration. This court's interpretation of the phrase adequate consideration is not precisely the same as that which the Inner House had formulated. This court holds that in determining whether adequate consideration was paid, the court must apply an objective test by looking at the commercial justification of the transaction, having regard to all the circumstances of the transaction, and on the assumption that the parties will be acting in good faith and at arm's length. The court agrees with the Inner House that there was no urgency in the sale which could justify Grampian accepting a price so much below what a full marketing exercise would have achieved, or, if such a marketing exercise were not possible, what a liquidator would have obtained by a sale in a winding up. Under the 1986 Act, it was for Carnbroe to prove that the consideration was adequate, and it had not done so. The Inner House, therefore, had been entitled to interfere with the Lord Ordinary's assessment. On the second question, this court holds that if Section 242, subsection 4, required the court to annul a transaction when the purchaser had paid a substantial price, albeit less than an adequate price, the creditors would obtain a windfall and the purchaser would be treated harshly. This is because the purchaser would have to return the property to the liquidators, enhancing the insolvent estate, while ranking only as an unsecured creditor in its claim for repayment of the purchase price which it had paid. Thus, the insolvent estate would get both the property and the price. That is an outcome which Scots common law does not allow when rescinding a contract induced by frauds, and the words of the section do not require such an unjust outcome. This court interprets subsection 4 of section 242 as allowing the court, in an appropriate case, to devise a remedy which would protect a purchaser in good faith who had paid a substantial but nonetheless inadequate consideration, for example, by requiring a liquidator to pay a sum to the purchaser as a condition for annulment of the transaction. Previous decisions of the Inner House to the contrary should not be followed.
The court will now adjourn.